All right, well, thank you very much. So we can move to the next slide. All right, so yes, so as said, my name is Ian Love. I'm a partner at the law firm of Corporate Immigration Partners, which does US inbound immigration. We work with Envoy Global, which has immigration and global mobility organization around the world. So I've been with the firm for over 10 years, handle immigration, US inbound immigration matters for companies in a range of industries, ranging from small startups, Fortune 100, admitted in 2 state bars. But what I'm going to talk about is just some of the kind of, let's say, shortcomings in the US immigration system currently that lead a lot of US employers looking to retain foreign talent to place their employees in Canada as a potential option if they've run out of US immigration options. We'll move on to the next slide. So one of the most common, and for many people, the only real option for gaining work authorization in the US as a foreign national is the H-1B visa. It's by no means the only one, but most others are limited by certain types of experience requirements or nationality requirements. H-1B is for any kind of job that qualifies as what's called a specialty occupation, which is just any kind of position that requires a specific level of bachelor's degree or higher preparation of study. It can be granted for up to 3 years, 3-year increments for a total of 6 years, but there are ways to extend beyond 6 years in certain circumstances. But for many foreign nationals seeking highly skilled employment in the US, it's really the only option they may realistically qualify for in terms of immediate ways to gain work authorization in the US. But as you'll see on the coming slides, there are a number of shortcomings, and the program has not been updated in many, many years, which is and has not kept up with kind of the economic needs of a lot of employers right now. We can move to the next slide. So this is an annual quota, which is colloquially referred to as the cap for H-1Bs, and that's 85,000 new H-1Bs. So for people who've never held an H-1B status before, can be granted an H-1B in any government fiscal year. And there's an annual lottery, which is just opening up for registration a couple of weeks from now for this year's lottery for the allocation of those 85,000 spots. So in the chart on the screen, you can see that the number in red at the bottom of each bar is that constant 85,000 available each year, and then the numbers overall for each bar show the total number of registrants seeking to be sponsored to be able to get an H-1B each year. And last year, it had a high of 780,000 people seeking 780,000 registrations seeking those 85,000 spots. Now, some of those were duplicates with multiple people registering with multiple employers, and the U.S. government's putting in some policies this year to try and reduce the incentive for people to register with multiple employers. But it does show, even if you take those duplicates out, there's still a significantly greater demand than the number of those 85,000 that are available. The 85,000 was increased briefly in the mid 2000s, around 2003 to 2005, but has remained, went back down to 85,000 as it remained at that amount ever since then. So there is an annual lottery that determines who can apply. So what's going to happen it's February still. So next month in March is that employers will put in their registrations for the people they want to select. There will be a random lottery. The lottery is random, except for the fact that people who have a master's or higher degree from a US university have a slightly higher chance of being selected than someone who does not have such a degree. But otherwise, it is a completely random lottery. There are people who will enter year after year after year and never get selected, and eventually may run out of US immigration options. And so that is what leads some employers to then be looking at ways to try and transfer their US talent they want to retain outside the US to other related companies. And Canada always looks appealing to many US employers because physical proximity, same time zones. And so that will segue into what our Canadian team is going to talk about as well. And then you can move to the next slide, please. So the H-1B is a temporary visa, non-immigrants in the more technical terms. It's a temporary status. It doesn't lead to permanent residency in the US, but it can segue into permanent residency. And so there's an annual limit of 140,000 on the number of people who can receive US permanent residency each year, or a green card as it's more commonly known, based on sponsorship for employment. But no more than 7% of the people who receive permanent residency in any given year can come from one country. So that means something like, I didn't have a statistic here, but something like 80% of people who are being sponsored through for H-1Bs and largely for US permanent residency for employment are from India. So when there's a 7% limit on any particular country out of the total set aside, but 80% of people come from one country, that then creates a huge backlog, huge and growing backlog for people from India, to a lesser extent from China, which is the second largest country of H-1B holders, which creates extremely long lines. So preliminary steps for even getting in this line are extremely time consuming in the best of circumstances, and these are currently being exacerbated even more by really record high government processing times for applications that would lead toward US permanent residency based on employment sponsorship. Takes a minimum right now, probably many individuals should expect around 2 years at minimum to even get in the line, which we'll see on the next slide, is once they get in line, the approximate wait times currently by country of origin, people who've been from India who've been in the line currently for about 11 to 12 years are now finally getting to the front where they can submit the final step of their application for US permanent residency. Those from China, about 4 or 5 years. Any other country, about 1 to 2 years, but those numbers are growing and are going to continue to grow unless there is basically legislation to increase the numbers that can be granted in each government fiscal year. There are first preference workers, which is a relatively small number of people who can qualify in the first preference category that have shorter wait times. But as I said, unless there's action which would require Congress, US Congress, to legislate on this point, those numbers will not change and will continue to get worse without some form of action to change these limitations. So faced with those challenges of wanting to retain foreign talent, employers will then be looking for transferring their employees elsewhere outside the US to Canada being one potential place they might look. And that allows me to introduce Daphne, who's going to come up and speak to some Canadian immigration questions.
Thanks, Ian. Welcome, everyone, and thank you for joining us this evening as we delve into some hot global mobility topics. So I will be speaking a bit about remote work as well as digital nomads. Next slide, please. Just a little bit about myself. I am a regulated Canadian immigration consultant at Envoy Global. And I've been in the field now in Canadian immigration right now for over a decade, advising clients in all matters of corporate Canadian immigration around temporary and permanent residence. Next slide, please. This is an agenda just for my part of the presentation. First, I'll be speaking a little bit about the different types of work permits that applicants can apply for or employers can support in Canada. And I think this will just really help contextualize the next part of our discussion, which will be about remote work in Canada, and then moving on to digital nomads. So without further ado, next slide, please. So I wanted to give a short background about the different types of work permits in Canada. And in Canada, there are 2 umbrellas of work permit types. The first is under the Temporary Foreign Worker Program, and that encompasses all sorts of labor market impact assessments, including the global talent stream, as well as high wage and low wage. And then we have the International Mobility Program, which encompasses LMIA exempt work permits, so including intra-company transfers, free trade agreements, international experience, and so on. It's also important to note that when we are applying for work permits, we also need to consider how we do it. So what's the mode of application? This comes down to whether or not the applicant is visa requiring or visa exempt. And if they're visa requiring, they must apply online. While if they're applying at the while they're visa exempt, then they can apply either at the port of entry or they can also apply online. It's also important to note that it can come down to the type of program, because some programs, despite whether or not you're visa exempt or visa requiring, you must apply online. And a good example of this is the international experience category. So why is this important? It's important because with employer-driven work permits, there is an element of a location. And when we're talking about location, we're talking about an address that the person is going to be working at in Canada. So that brings us over to my first big topic of the night, which is remote work. So by show of hands, and if you're online, if you can also type into the chat box, how many people think remote work in Canada is allowed? Okay, a couple of you. And how many people think it's not allowed? Okay, a couple again. And how many people think it depends? Love it. There's so many people who think it depends. It's very, very legal representative of all of you. So that's exactly right. It really does depend. It comes down to a case-by-case basis as well as the discretion of the reviewing officer. Moving on to the next slide. We found that we've had quite wide success with remote work requests during the pandemic. And now that we're sort of past the pandemic, we're still seeing success with remote work. However, I think we will slowly start to see this shift, and really depending on the specific officer's review. I will be speaking a little bit about a different case on a future slide, but just something to keep in mind is that there's no one size fits all. It really depends as to what the circumstances of the case are. Just going back to the background that I was providing in my first slide, I wanted to just cover how applications are reviewed for LMIA and LMIA exempt work permits. For LMIA exempt work permits, it's a one-stage process. It goes directly to Immigration, Refugees, and Citizenship Canada. Whereas for LMIA-based work permits, it goes first at the first stage to Employment and Social Development Canada, and then it goes to Immigration, Refugees, and Citizenship Canada. So for LMIA-based work permits, that means it's a two-stage process, which then means there's technically room for scrutiny at both levels. However, with that said, LMIAs have been pretty straightforward in terms of requesting for either hybrid work, remote work, or just regular in office work. And typically, because it's a two-stage process, and the first stage acts more like a pre-approval for a work permit. Once the first stage is approved, we typically don't see any issue with the second stage, because the second stage is really more about background checks and admissibility requirements. Whereas for international mobility program work permits, so things like the intercompany transfer, it can really be scrutinized down to the exact eligibility requirements and the interpretation of it. Also, going back to my background slide, I also wanted to touch upon how applications are reviewed both at the port of entry as well as online. So when you're requesting for something discretionary like a remote work, the ability to work remotely, when you're making that application at the port of entry, this can be risky because it comes down to how the officer will review it. And if they decide to refuse it, that means you could be returned back to your home country or the country that you just initially flew from on the next available flight, unless they allow you to come in as a visitor. So as you can imagine, that could be quite disruptive, and no one wants to be turned back, right? So that's something to keep in mind when you're talking about strategy and how you want to apply for the work permit if you have that choice. With online applications, it's a little bit easier to deal with just because you're typically somewhere where you have status, so it impacts a little bit less if you get a refusal. But I mean, of course, it still comes down to how the officer will review it. And if you get a refusal, then it's something that will be on your immigration record that you have to disclose for future applications. Now, even with remote work, while you can make a request to work remotely, there still needs to be a city of employment that's listed, just for prevailing wage purposes. So the prevailing wage is determined based on a national occupation classification code, which is a government code that is aligned to the particular position that you're working in Canada, as well as the city of employment. So while you could request for work, let's say in the city of Vancouver, that means you're only, and it's approved, that means you're only allowed to work remotely in the city of Vancouver. You cannot move around Canada at will, unless, again, it comes down to really specific exceptions. If you had requested and were approved for an open work location, then you could move anywhere. If there are specific conditions that allow you to, then you could. But typically, it is tied to just one particular city, which means that if you wanted to move from the city of Vancouver to the city of Toronto and you were locked into that particular city, that means you would need to apply for a change of conditions application and either receive an interim authorization or receive an approval on the application before you can move to that city for compliance purposes. Now, just moving away from the work permit side for a bit, I also wanted to note that just because you are approved for a work permit with remote work doesn't necessarily mean it covers you for the rest of your immigration applications in Canada. So once you've come into Canada, you've got a work permit, and now you've decided you want to stay long-term, you want to apply for permanent residence. Does permanent residence allow remote work in terms of, points, in terms of eligibility under different programs? Depends. So with the federal programs under Express Entry, so things like the Canadian Experience class and the federal skilled worker category, they have been fine with using remote work for points in Canada for Canadian experience, as long as they have Canadian authorization to work, that they've got a Canadian employer, and they've been working legally in Canada. However, if you're looking at using the provincial nominee program, that's when it gets a little bit more dicey, because the provincial nominees or the different provinces haven't quite caught up to the notion of remote work. And a lot of them, the employer-driven streams, are still very traditional in the way that they interpret things, and also needing a specific physical office to house their employees, for their employees to be actively working at to carry out their job duties. So if you have an employee who is working either in a hybrid situation or a remote situation, it can be a little bit risky. Fully remote is still a no-go for most PNPs. However, for hybrid work, some provincial nominee programs, some provinces have been okay with hybrid work. So it would really come down to your appetite for risk in terms of whether or not you move forward with those applications. I do want to also caution you that with the use of these provincial nominee programs, BC in particular has been quite, they've been known to scrutinize a bit. And we've had quite a few, not quite a few, but we've had several clients now be physically audited by BCPNP officers who go into their office to make sure that there are actually people working there and that it's an active organization or an active company premises. Next slide, please. So around the concerns for remote work and interpretation of eligibility. So the first point I've already sort of covered, that it's really discretionary, down to the officer's discretion. So I wanted to also cover how it's looked at from an officer's point of view, because when you're requesting for remote work, the officer also considers whether or not employer compliance can be met in terms of meeting workplace condition requirements, whether they have the ability to conduct inspections, as they sometimes do from time to time. And when you have remote work, it means the employer it's like opening Pandora's box, where you don't necessarily know how their working conditions are if they're working remotely from home. You assume they're not working in an environment that's non-conducive to work, but you don't really know, right? And officers can be concerned with that, and that can be a point of scrutiny as to whether or not they'll approve remote work. This brings me to the next point, which is a recent case I wanted to share. It's actually the first case that we've seen to date around some pushback on remote work. And it was a case for a multinational company who has used this program before. It was an intercompany transfer application. They met all of the eligibility requirements. They also had a Canadian premises, but the problem was that they had a remote first HR policy, and they also only required the applicant to come into to come into the office quarterly, so only 4 times a year with remote first. The officer took the approach that because they took the interpretation of the wording of legitimate and continuing establishment as being physical establishment. And with all of the information that we've seen in the regulations, there's no indication to indicate that it must be a physical establishment. And we've also seen from practice as well, with all of the success that we've had with remote work requests, that that's not the interpretation that other officers have used. So again, when we're talking about the discretion of reviewing officers, there is no consistency around how officers actually review each type of application. So when it comes to a gray area of something like requesting for remote work, employers really need to be aware that just because they've had previous successes or they've heard that other companies have had success, it doesn't necessarily mean they will have the same success, and it can really, again, be to the mercy of the reviewing officer. Next slide, please. So that covers the first portion of the heaviness of the topic of remote work. So I'm going to just shift slightly to digital nomads. So what is a digital nomad? A digital nomad is someone who can work remotely from anywhere around the world without needing to be in any particular place. The Canadian government has not provided a whole load of information about digital nomads. It wasn't until recently that they provided a little bit more details, but not to the level that we would hope for to have full clarity about the program. And it's also something that was only recently talked about or announced last year. So while it was announced last year, details about it was only released, almost half a year or more later. Next slide, please. So for digital nomads in Canada, they do not require a work permit. They only need to come into Canada as visitors. So thinking back to the background slide for visa requiring citizens, that means they need a temporary resident visa, or if they are visa exempt, they need an electronic travel authorization. And if you're one of those lucky exceptions like US citizens who don't need anything, you just need to come in with your regular travel documents. Digital nomads can stay in Canada for up to 6 months, and they can work for remotely for their employer. Or if they're self-employed, then they can work for themselves, providing services to people outside of Canada during this time. While they're in Canada, they can also, they can look around. They can, if they get an offer of employment from a Canadian company, they can apply as a visitor for a work permit while being in Canada. This is due to a temporary public policy that is in place until February of next year. And with that public policy, they're allowed to apply within Canada, but must remain in Canada until a decision is made. But something to note is that depending on when they actually apply, that 6-month mark may be met, which means if you've applied for a work permit as a visitor and that 6-month mark is met, at that 6-month mark, you must stop working as a visitor nomad. So you cannot work for yourself, you cannot work for your foreign employer. You must simply remain in Canada as a visitor until your Canadian work permit application has been adjudicated. If you're accompanied by any family members, like a spouse or children, if they intend to work or study in Canada, they would need to apply for their own documents. I think that's okay. Yeah. Now, moving on to the next slide, please. The hot question: can you extend your time in Canada as a digital nomad? The short answer is no, you cannot. You cannot extend your time as a digital nomad. You can extend your time as a visitor, but you cannot stay here, apply for an extension of your visitor status, and continue to work as a digital nomad. Does this mean you're not allowed to come in later on and use this program again to work as a digital nomad? No. So right now, with the very limited details that the government has provided, the wording says that you can come to Canada for up to 6 months to work remotely at a time. So at a time signifies that you can potentially use it again later on. But what the government has not made clear is if there needs to be any specific time in between when you actually use it again to when you initially came in to use it. So if you've come into Canada for 6 months, you leave for a day and you come back, is that possible under the current rules? Yes, technically. Should you do it? Probably not, just because we're also thinking about other reasons, like CBSA officers who can see every time you've come into Canada. They could have concerns about your bona fide reasons for coming into Canada and your long-term intentions. And if they don't believe that you plan to leave, or if they think that you plan to stay for a longer period of time than allowed, they can also refuse you entry, which then goes towards your immigration record that you have to disclose for any application that you make in the future. So I know that was a lot of heavy information that I've just thrown at you, and I'm sure you're also very curious about what the implications are on the tax side. So with that, I would like to hand it over to my colleagues, Randall and Christine, to go over the complex tax implications. Thank you.
Yeah.
Coming up with you?
Yeah.
All right.
Thanks, Daphne. Yeah, so, you got a lot of information about the immigration side. Randall and I are here to talk through the tax side and the concerns on that end as it relates to digital nomads and remote work. And there's a lot to unpack here.
Absolutely.
Yeah.
Absolutely.
So I guess let's go to the next slide, a quick introduction.
So that's me. My name's Randall Tim. I'm a director at Trowbridge. I've been around for a couple decades now. I've had opportunities to speak at various Canada Payroll Association, CERC, and I used to spend some time working for CRA in their International Tax and Audit Division. So without further delay, next slide.
Yeah, and I'm Christine. I've been in the mobility space for about 15 years. I've been a speaker at a couple of events, USPA, Clever Firm events, this one. I'm a director at Trowbridge with Randall, and I'm a chartered accountant, CPA. Next slide. So I guess an overview, which, Daphne covered a bit as well, but the idea of the difference between remote work and digital nomad, and it's important to think of this as a pre-COVID and post-COVID. So pre-COVID, remote work was a thing. There was remote work. There were many situations where an employer was dealing with a couple of people that were remote. It wasn't nearly as
Prevalent.
Yeah, prevalent. That's the word, as it is now. And basically, what happened was COVID happened. Everyone realized that they needed to pivot, get equipped to work online. A lot of people were stuck physically where they were. Borders were closed, planes were not flying. It was something that was pretty monumental in the way that people work. And what came from that after the COVID calmed down and people got back to a more regular routine was that remote work kind of stayed. There's a couple of reasons for that. One, people have enjoyed the flexibility of having that arrangement. Sometimes it's out of necessity. So we've all heard the term like talent crunch, or, it's difficult to get the right people in the right roles. And this opened up a lot of doors in terms of not limiting by like physical location, who you're working with. So that's kind of, it's important to think about that, how monumental of a shift this was. And where pre-COVID, there was like a couple instances maybe that you had to deal with and you worked it out. Post-COVID, it's rampant. And so within different employers, HR is getting involved, finance is getting involved in terms of realizing how widespread this is and how they need to create some policies around it to protect the employer themselves from their requirements of what they need to do. And there's a lot on the tax side that they need to do. It's not easy. It's not, set it and forget it. It's really, there's a lot to do when you have employees in different locations.
And that's the thing, right? Employers didn't know. Nobody knew. We were in a whole new world. COVID had happened. CEOs of companies had cottages in the Muskokas, and they're like, I'm leaving Texas and I'm going to sit in Canada. I'm allowed to come to Canada. That's what I'm going to go do. But they continued, and they continued to work. And employers were just whatever. We're all just, and the governments were whatever. Just be safe, everyone. And now what's happening is, COVID's died down. Employers are going, okay, we've heard about some of these potential issues, some of which we'll cover off today. What's our policy? We need to have a company policy with regards to how many days someone can just pick up and go sit in Canada, sit in the US, sit in Barbados, sit in wherever. What are the impacts? So that's what we're seeing with companies now. They've put in those policies. Is it a 10-day, 20-day, 30-day? They might not do anything, but this is what's happening. So we're seeing that in the HR world. They're referring to it as a remote work arrangement. I think we can pivot down into the digital nomad, and I think there's a bit of a difference there.
Yeah.
Because, why don't you?
Yeah. So digital nomad is a different kind of arrangement where it's less defined in terms of where the person is sitting. In some cases, the employer or the person paying them, at least, does not even know where this person is. They could be here in one location 1 week and another location another week, and that's just the arrangement. They're a digital nomad. They're really able to do their job from anywhere, and so they do. And there's quite a difference there. Remote work is generally an arrangement that is set. You work here, you work for us, and it can be for a certain period of time, or it might not be, but it's more defined and set. And digital nomad is a situation where people can work from anywhere, and they will generally travel wherever they want.
Yeah, they just, they're not really, I guess probably the easiest way to see it is this, and to Daphne and Ian's presentation, I know that there's some immigration legislation coming through with respect, and they're calling it, I think, digital nomads, right? And, when we think about it, it's really from a tax world or from an HR world, I think they would all look at it from a remote work arrangement. Digital nomad more so is, I'm self-employed, it's Toronto in the winter, no way am I going to be here. I'm going to location X to enjoy the nice weather. And after that, I'm going over here and then I'm going over there. So I'm not really tied to an employer because, again, the employers have put forward all these rules and requirements to a certain level with respect to someone asking, can I please go work in country X? Or as a digital nomad in kind of the HR tax world is, I'm more or less self-employed. I'm just going wherever I want to minimize, or maybe the use word avoid, paying taxes as much as possible. Next slide.
So some typical examples of what we're seeing in the space of remote work arrangements and digital nomads, and there's been a lot. And pre-COVID, we saw this sometimes, especially in regard to some of the stuff Ian was talking about, parking people in Canada for a period of time, waiting out a visa in the US. But other situations that we've seen come up a lot in the last couple of years have been foreign-based company with employees who just want to travel around and they want to sit in Canada for a little bit. Another is a lot of border work. So there's some people that would have ordinarily gone to the US every day. Say you're in Windsor and you're going over to Detroit. It's like a short little drive, and that was what you did before COVID. But now post-COVID, you have the ability to work from your home in Canada. So that's, a situation that has come up a lot. And then another is like Ian was talking about, the foreign-based company with employees whose visas are going to expire, and they park them in Canada where they can be for a little bit and then head back to where they were meant to be.
Yeah, and to all those examples, what has the government done in their legislation? Again, immigration's coming forward with some language, but what about finance? What about CRA and their administrative policies? Right now, everything's, well, let's go to the next slide and see what happens.
Yeah, so there's been a lot more questions on this coming up because of the frequency with which it's happening. There was a question at a CRA roundtable on this topic, and they asked, we would like to hear the CRA's thoughts around whether USCO, so a US employer, may be considered to be, one, carrying on business in Canada for the purposes of the Income Tax Act, and if so, two, earning income through a permanent establishment in Canada if 50 of the 1,000 employees that work at the company are Canadian residents or remote workers.
Yeah, now we're not going to go through the definitions of carrying on business or permanent establishment. We do have Brandon here, so if somebody has a question, I'm sure they can ask that later. But the idea is this, is where you have these individuals situated in Canada, does that place the US company at some level of risk from a corporate level as to either a tax filing, which is generally carrying on business, or if they have a permanent establishment whereby that US company could in fact have a branch in Canada and be subject to tax at the corporate level. So these are things that obviously, if we go back a couple slides, these are things that companies have to be aware of. What are the risks from a corporate level? Not only the individual, but the corporate level as well. And, corporations generally take care of themselves first before they look at the employees. So let's go to the next slide.
So what the CRA has said in response to that question was that there's been no change to the way that cross-border remote work arrangements are accounted for. There's been a lot more of it lately, but nothing has changed in terms of the treaty or the relevant legislation. So it's pretty much status quo, really, in terms of the reporting required. And that's what's scary for employers, because they don't realize, or maybe they do, that there's payroll requirements in Canada. And Canada's very harsh with this. It's very,
And we'll cover off that in a couple slides.
Yeah.
Next slide. So nobody can read that, I don't think, and I'm not going to read it for you. But effectively, all that's saying is this: Canada's status quo at the tax level. So whatever rules were in existence pre-COVID, and now with all the fundamental changes in how HR and individuals are working, it's still the same. So there's been no change. They haven't caught up. And for those of us who've been in the tax world for a number of years, and I'm looking at some of you now, it takes CRA and finance a long time to catch up. So right now we're still in the same status quo. Next slide. Okay, so I get to talk a little bit about legislation, which of course is everyone's favorite topic. Here's the thing. Canada has rules and regulations in respect of payroll, and this is at the corporate level. So what you'll hear a lot in the tax world is you'll have someone call and say, well, John's going to come to Canada. He's going to be in Canada for less than 183 days, because that's what we're going to do as a, excuse me, as a remote work. We're just going to send him to Canada for 5 months. We're good. He's not going to be taxable less than 180 days. This is always the words and phrases that they throw out. But the legislation itself is very specific. And the words that are used there, and I won't read the slide, but effectively what the law says, it's every employer. It doesn't specify that it's Canadian employer, which means US Co who parks someone in Canada, sends some, or someone says, can I go work in Canada for so many days? That corporation has a tax requirement for Canadian payroll tax. And that is potentially Canada Pension Plan, EI, federal and provincial taxes, not to mention some of the potential, and again, it all depends on how the corporation ends up, be it just carrying on business or permanent establishment as well. So they may have those types of additional tax filings, but the legislation itself says individual is subject to income tax. Well, wait a second, they've had this idea that if I'm in Canada for less than 180 days, I'm being paid by my US company. Why would I have to go through this? This is Canada. This is our red tape. This is the way that we CRA, capture and understand what's going on. How will they know? This is how they'll know. We can talk more on the corporate side. There's specific forms that have to be filed with companies that are carrying on business. Schedule 91 is the famous one, whereby a company has to list all their individuals that are working in Canada. And by that, it's really shooting fish in a barrel for a CRA audit, because they can use that form to determine how many employees, the amount of employment income that's allocated, and in addition, independent contractors who might be hired to work in Canada for the company. And those are all the sections of the Act that we won't have to read through. Next slide. Okay, so, all right, there are ways for the companies to, I don't like using the word avoid, but I'm going to use it, to avoid these payroll requirements for these, again, people that live in the US, sitting in Canada for the summer, and then returning. So one of the ways is a corporate waiver called an RC 473. And what this does is it, once approved by the CRA, it removes, under certain conditions by the employee, the requirement to withhold and remit tax. So it is predominantly used for many of our clients. Unfortunately, the turnaround time by the CRA is not conducive to having it done in the time frame that you may need to move these people into Canada. We're seeing, I don't know, 6-8 months for processing of this form. So if you need this form in place and you're about to send, again, in that example prior, 50 people to Canada, you may have to withhold tax on all of them until that approval comes through. So if they were coming in January, you might have had to apply back in May of the prior year. So it can create this issue. Now, of course, the US company, in order to, if they are remitting payroll, have to register for a Canadian business number. They have to get a Canadian payroll number. What about the individuals now? Do we go down there? We're talking Reg 105. Okay, so that's kind of the corporate side of what they have to do. on the independent contractors. So if you truly have what we've referred to as a digital nomad, that's a self-employed individual who's just coming to Canada to hang out for a while. Well, if that individual is performing services in Canada and being paid either by a Canadian company or even by a US company, hey, we want to hire you to come work in Canada, there's a requirement under Regulation 105 for a 15% withholding tax on that payment to that non-resident independent contractor. Again, that individual may apply for an individual waiver, again under Regulation 105, by stating that they don't have a permanent establishment in Canada. They would get the waiver, and then there's no requirement to withhold tax. But as you can see, there's a lot to do just for someone that wants to spend the summer in the Muskokas. If you're an employer sending someone to Canada.
It's also a matter of knowing where your people are, because you cannot even begin to file some of this stuff if you can't explain where they are. And one of the requirements of the RC 473 is to be able to provide the records if the CRA asks for it as to where your people are. So that's a big challenge, and it's something that I know a lot of companies are trying to grapple with, is that how to track people if there's no formal way to ask for approval for this remote work arrangement. It's a challenge, and it takes someone taking ownership of that piece of it at the company to try to wrangle it, because it's getting better, but I've seen a lot of companies that just don't know, don't care, like they're just sending people, and there's a lot of stuff they need to do on the back end to make that okay, and that's why the policies are coming into place. Just because you can work from anywhere doesn't mean that it's a good idea in some cases.
Next slide, Brittany. Okay, so not only is there payroll withholding requirements for the employees and or the independent contractors, there's also filing requirements by the employer and by extension, maybe even the employees. So the employers would have the T4 filing requirement. So for those that are from the US, equivalent to the W-2. And then of course, well, for the non-resident, the independent contractors, they'll have to issue a form T4ANR, which is again another filing requirement that's required by the payor. So again, all these things that people don't think of because John just wants to go sit in the Muskokas at his cottage for 3 months. And in the absence of knowing all this, what could happen? Let's go to the next slide. Oh, okay, we're skipping the residency. Okay, so we'll save the penalty fund stuff for after. So one of the things that certainly did happen, or certainly things that were having to be considered back in the COVID era, was when these individuals came to Canada, they were staying. And the government at the time, the CRA, didn't really have a policy. What happens if you're trapped in Canada? Eventually that came forward and rules were put in place. But certainly now, in the absence of that, we've got John who might be coming to Canada, and you know what? He kind of likes it here, and he's a Canadian citizen, but he works for a US employer. So he can come in, right? Doesn't matter, he's a Canadian citizen, he can come into Canada. Now he's saying 8, 9, 10 months. Maybe he doesn't want to go back to the US for a little while. So the concept of tax residency for that individual in Canada becomes a question that may have to be looked at. And tax residency is something that's more based on a common law approach. It's kind of outside of the scope of this discussion, but it's certainly something that may have to be explored if the individual desires to stay much longer than that, you know, a reasonable amount of time. Various questions that, you know, have to be looked at when you've got these individuals that are looking to extend their stay or even just go to Canada. You want to make sure that you have that understanding from an HR perspective, from an employer perspective, to protect yourself. Next slide. Okay, so will the employee be a resident of Canada? Again, it's all facts and circumstances based. Digital nomads and remote work arrangements be considered to be non-residents of Canada. More likely than not, you know, what's that, 50 plus 1%? You know, where there's a defined time that they're going to be in Canada, we know they're going back to their home country. Yeah, we should be okay, but what if someone parks an individual in Canada with the thought, you know what, I'm going to get that H-1B, I'm going back to the US by September. I know it's February, but I'm going to win. And he doesn't win. What happens? Now he's staying in Canada for a longer period of time. What happens now? What are they going to do? Are they going to transition me onto Canadian payroll and becomes a Canadian employee? And think of all the implications of that. I was on a US contract, now I'm going on a Canadian contract. What are all the implications that you have to consider? Because they don't always win. I think it was 7%, if I remember, Ian.
Well, it depends on the number of entrants.
Right. But there certainly wasn't a guarantee that you were coming in. So
Less than 50%.
yeah, exactly. So you have to again explore those issues potentially when you're sending these people to Canada for that sole purpose of stay in Canada, you're safe there, and we're going to bring you back when you win. So
the tricky thing too is it's an individual determination. It's the employer has no say in what they want it to be, but the individual's facts and circumstances will dictate this, and it's not always the employer's place to know, you know, the personal situation of the employee and what their residency ultimately is. So it's a bit of a balancing act, but the requirements on the employer do depend on you know, residency. So it's a tough one.
next slide. Okay, so yeah, we can skip that slide. That slide there is more, so CRA has put out something, I'll just talk to it briefly. Again, legislation will eventually catch up. So right now, CRA has put in the concept of remote work, but more from a Canadian domestic rule. And the idea being is, what is your province of employment for the purposes of working in Canada? So, you know, if I lived in Manitoba and Trowbridge is my employer and I'm paid from Toronto, would I show Manitoba as my province of employment or Ontario? Historically, it's been Ontario. That's where I'm being paid from. That's where I report to work. But I'm on a full-time remote contract, so more likely than not, it would be Manitoba. So these are where the rules are making changes. So CRA is slowly catching up to all these issues. And that's just the domestic. So the international stuff will take even longer. Next slide. Okay, so penalties. So this is the fun part. So how will they know? They're going to find out. How will they know? CRA is, so the US company that sends their people to Canada has that requirement. We spoke about it, the payroll withholding taxes. And the penalties can be, depending on the number of individuals, depending on how long they're there, it's based on the amount of tax that was required to be withheld and reported at a percentage of 10%, up to 20% for willful neglect. So what we have to look at is, you know, what is that potential cost, right? It's a true penalty. Will CRA find out? Well, if the company is doing business in Canada, they have a corporate treaty-based tax filing to do, Schedule 91, and it lists all the salaries. It's a very easy inquiry at the audit level. If the company has a permanent establishment, it's just as easy, if not easier. So those penalties do exist. In addition, right, when you cross into the border on a regular basis, if you're commuting into Canada, at some point, the customs officer has to start asking a question. How come you're coming back so often? What are you doing? Why are you here? Who are you working for? And those questions will eventually be asked. I certainly get asked when I go to the US, who do I work for? At the same time, the information between customs and CRA does get exchanged. It's a slow process, but it does get exchanged. So they can find you if they want to really look. We talked about the penalties for failure to withhold. Obviously, interest is always applicable. And then slips, there's penalties for slips or failure to file the T4 slips, which we talked about before. Those penalties are relatively minor. They're still there. It's more of a nuisance penalty than anything else. But the 10% of the absolute tax. Now, here's the other fun part. If we think about it for a second. So you have, and my numbers, I don't have a calculator, so I'm going off the back of my head here. Let's assume that we have income for 50 people in Canada. We didn't file a waiver form, and we have $100,000 of taxes that should have been withheld and remitted to the CRA. So I'm a US company and send 50 people to Canada. So the penalty on that is $10,000, right? 10%. plus interest, whatever, we'll say $10,000. Well, when CRA comes knocking, well, this is where it gets messy. CRA comes knocking, they find you. So they're gonna hit you with the $10,000 penalty. CRA may also help you, because they're very nice this way, and prepare the T4s for your company, for all those employees that were in Canada. Well, you're gonna have to still remit that $100,000 of tax. So yes, you paid the $10,000 penalty, but CRA now wants $100,000 because you should have withheld and remitted the tax from those individuals to Canada. So now the company's at $100,000 plus the 10% penalty. And what if Randall's one of their employees and he's no longer an employee there and he had, let's say, $5,000 of taxes that should have been withheld and remitted? He's in the US, works for the US company. Is he going to file a return? Maybe get the money back? If not, what happens? What happens if Randall's no longer an employee of the company? What are we going to do? We've just paid his bill of $5,000. He's not going to file a tax return. He may never get the money back. We've got a benefit to this individual that has to be paid. So CRA won't make it easy when they catch you. They'll make it tougher. So something to always be on the lookout for. I've had clients that got caught because they wanted to take the risk. So it does happen. This client got hit with 3 years and $1 million worth of tax withholdings that had to go in. They rolled the dice. It didn't come up 7 or 11. So something to be aware of. Again, I think, you know, remote work is here to stay. People do want to go to different locations. You as an employer need to make sure that you have some level of policy or understanding in place to make sure that your company, the corporate side, is protected and that the individual's activities aren't going to put them offside in that other country. So I think that might be the last slide. I can't remember. Let's go to the next slide. And any questions? So I guess that was. So. Okay. Well, depending on how they follow the rules. So
repeat the question. Repeat the question.
Yes, I will. Okay. So the question is, in the example that I provided, what could have happened had the company followed the rules? What would have been the net result? So it depends. As always, a tax answer is it depends. So what would have happened or could have happened is one, in this particular example, all the employees would have qualified for what we call the RC 473. So this is the corporate waiver, which would have covered all the employees. So if they had filed that in time and it was approved, they would not have had to have withheld any tax for any of the employees. So that would have been the best result. The next best result would have been, shoot, we didn't do that. We'll remit the tax, and there would have been some types of internal arrangements, which I think is a little outside of this call. But what would have happened is they would have set that up, paid the monies in, and required the individuals to file tax returns. Since they are not residents of Canada, since they were in Canada for less than 183 days, and the monies would have been refunded to the individual. And depending on whether or not the company funded those tax amounts or whatever the arrangement was, the company would have been able to recover those taxes. So net result would have been, again, net zero tax. But it's all this corporate red tape that the CRA requires, which is what the employers have to do. Does that answer your question? Okay.
It's also really hard to do after the fact.
Yeah, sometimes, yeah.
Yeah.
So Brittany, we'll maybe go to an online question if there's any questions from online.
We don't have any in the chat just yet, but if anybody wants to speak up or type in a question, then feel free, please.
Okay. Any questions in the house? Yes.
There is an employee works for a Canadian company and they're transferred to another country that's still working for the same employer. So, like the original job was in Canada, it's sent to another country, same role. It's still a tax transfer.
So Randall's going to repeat the question.
Okay, so the question was, we have a Canadian individual who is going to another country to perform the same role for the same Canadian company in the other country. And whether or not that individual will be a resident, continue to be a resident of Canada. Do you want to handle that one? Or do you want me to? I'll do it. I'll do it. All right. So the fun is residency is independent. And because it's based on individuals' facts and circumstances. So to say whether or not the individual would be a resident of Canada or not is difficult to say. When we look at tax residency, in a nutshell, we're looking at the concept of residential ties. Again, it's a common law approach. So we're looking at residential ties both from a primary and secondary perspective. So is the individual under primary, married, house, spouse in Canada, or independence? Secondary ties really run the gamut from landlines, cell phones, memberships in clubs. Gosh, there's so many things. Passport, financial accounts, keep on going all the way down to even burial plots in Canada. So the famous Thompson case, was it like 57 or something like that? Like a long time ago, really outlined almost the full administrative policy of the CRA. So in your example, it's difficult to say because we would have to look at it. So if I'm single and I'm living with my parents, I'm throwing my computer in my backpack and I'm going to that other country. Probably, and then how long am I going to be gone for? Am I getting an apartment or renting something? More likely than not, I'll become a non-resident. But let's use Ernie, who's standing beside me. Ernie's married, lots of kids, beautiful home. He's not leaving everyone behind, but he's going to go for a couple of years. He hasn't really severed his ties with Canada. So he would probably remain a tax resident of Canada. So it's hard to say, but you'd have to look at each individual situation separately.
Yeah, so, it really Canadian employer transferring Canadian dollars.
Okay, so the follow-up to that is whether or not it's more at the employer level or with respect to the residency change because they're moving to a different country, or is it remaining at the individual level? And again, the employer piece, there's other aspects that you have to consider if you're doing, from an employer perspective, right? If I'm in Canada, I've got certain types of employment law that I have to follow. If I'm being transitioned to, I don't know, Croatia, well, what are their rules? Because if I'm going to go there for 3 or 4 years, whether I'm a resident or not, is my employment contract have to change? Even though I'm still an employee of Canco, there might be other rules and regulations within Croatia, just using that as the example, that you may have to alter that employment agreement. And I think it was Daphne, you talked about a wage increase, if I remember correctly, right? Right, when you come into Canada. But I mean, again, just using the reverse, could there be something similar in a country like Croatia? I don't know, right? So we always have to think about these items when we're sending people. From an employer perspective, just to kind of add on, let's say that this person's a high-level VP and he's signing contracts and you're trying to grow the business in Croatia. Well, gosh, what are their corporate rules with respect to that individual? Could they be carrying on business in that country? Are there filing requirements into that? Could this individual have created what we call permanent establishment? Anything's possible. We'd have to look at those domestic laws. So there's lots to unpack.
Yep.
Sure.
Two comments. The first one is one of the main criteria of determining the residence, where your children go. I think, especially minor children, it's not that easy to sever the ties. If basically your children still trying to find out go to school to Canada, you probably want to get that main criteria. And I would add one thing: when people are sent over to another country, it's fascinating to see how they overlook other issues, which are quite fundamental. Because let's say they have a major health issue, even worse, they pass away over there. They don't understand they have created a whole bunch of completely different issues they have not thought about. Oh, they have a fantastic interesting one. Employers send people over. In 3 years, you have tax, you have regulatory, you have legal, you have estate planning, you have so many things. Like you just can't send people there. They have to be planned. They have to be well thought through because otherwise, at some stage, you will have an issue.
I don't disagree that there with, so just for those that didn't hear, and I don't know if I'll be able to, I'll try and encapsulate everything. The question or the statement was really based on looking at particular factors in determining tax residency, and then by extension, other items that one would have to consider when an individual is going outside of Canada, such as legal, estate laws. I guess that's kind of, again, I'm just trying to encapsulate it. I would say to you this. I would say that children in school in Canada, I'm going to go with it depends. And I'll tell you why. I'm married. I've got one child. I'm selling my house. I'm packing up everything because my child, who's a child, so under 18, is going to Ridley College in Toronto. Or I think Ridley's in Toronto. St. Catharines. All right, thank you.
I'm from St. Catharines.
Oh, there you go. I don't know why I thought of Ridley, but anyways, so they're in a boarding school. Under the age of 18, they're taken care of, but they don't have a house to go to. And if I pack up all my belongings and I move to the US, I move to England, wherever I move to, the fact that that one individual is still here in Canada, more likely than not, would not keep me as a tax resident. Again, it's all these factors that you have to kind of put into.
Aggregate.
Yeah, I mean, there's no weighting system per se, right? Like house, spouse, and dependents are as strong as all the secondary ties is probably one way of looking at it, but everything has to be taken into consideration. It's a fun part of the tax because it's really not defined. So you can play around with it a fair bit.
So Brittany, are there any questions online?
No, we don't have anything right now, unless anybody wants to speak up, but there's been nothing coming into the chat.
Brandon and then Dimitros. Yeah.
I just want to check with Randall, make sure he's not living with his parents.
So the question was, does Randall live with his parents?
During the summer, yes. At the family cottage.
I guess just maybe the one thing I just kind of wanted to ask or maybe mention. I think it's critical in terms of whether, let's say, a digital nomad, whether they're a resident of a treaty country. That distinction, I think, is critical in terms of again, when you have treaty most protection, so it's a non-treaty country, then the digital nomads can be deemed Canadian residents.
Yeah, I think that's a fair statement. So again, I think it might depend on the length of stay in Canada. So the question from Brandon, not the first part of the question, was just asking me about my personal life, but the second piece of the question was in respect of digital nomads specifically, and whether or not if they are coming from or going to a non-treaty country, what would be the potential with Canada? I think that's a fair statement. So in respect of that, you know, where Canada doesn't have a tax treaty and we've got individuals coming into Canada, or in the case of even leaving Canada, we have to be cautious with respect to number of days test. And this is probably the only reason, again, we're looking at digital nomads as being independent contractors. So they're not employees of USCO, for an example. So if a digital nomad comes into Canada from a non-treaty country, there is no treaty protection. So a great example, I guess, and it's not necessarily a digital nomad, but the concept still applies. So I had an old client who lived in the Caymans where there's no tax, but for whatever reason, he liked spending about 185 days in Canada. So because of that, under Section 250, the individual was considered to be, or deemed to be, a resident of Canada. Doesn't matter about all the residential ties. He's coming from a non-treaty country, and Canada has that rule in place almost specifically for this. So the individual in this case was fully taxable in Canada. Now, with regards to independent contractors, it's a little bit different in the sense that, you know, if they don't have a treaty country, they probably don't have much to hold on to. So, you know, I think it's, again, tough question, but, you know, circumstances under each situation have to be considered to determine what the necessary outcome is. But regardless, if that person's coming into Canada as an independent contractor and being paid by someone even outside of Canada to perform services, that 15% withholding is going to apply. Yes, sir. Young man over here.
So actually, this is maybe you're asking. You mentioned that somebody can come into Canada for 6 months of work as a digital nomad.
Yep.
Just need a bit.
Up to 6 months, yep.
What permit? So it's not permanent. It's
Visitor status. Yeah, so
they have to indicate whether they're business or pleasure. You know, when I go to the US, it was asking me, is it business or is it business?
you would only come in as a visitor. So let me just
could you
repeat the
restate
question. Yeah. So the question was, if you're coming in as a digital nomad, what do you put if you're applying for an ETA? Is it business or pleasure? I would be putting, it depends on what the options are, but I think I would skew more towards visitor for visitor reasons, because you're not coming in to do business per se. You're coming in to work while being a visitor. You don't need a work permit. But if you're considering business visitor purposes, that's something different. You're not coming in as a business visitor. You're coming in as a visitor to work as a digital nomad at that, you know, for yourself or for a foreign worker, but you're not doing work for like a Canadian employer, or you're not coming in for business visits on behalf of another employer, for example.
Okay, so then these now. So you're there from day one. You may be subject to tax in Canada, but you're on a visitor's visa. You try to apply for 19, they won't get it to you because you don't have a work permit. You try to apply for Social Security number, you know. How do we manage that in terms of how do we get paid the government? Because if you stay even 10 days, you may be liable for tax in Canada. Especially more than 93 days and not going to treaty country. You're paying tax for a whole year. But there's no mechanism in place to pay it if you can't get an item.
Yeah, so
Restate the question.
come on up and restate it. No, the question was about, so it led from the visa requirements for someone coming into Canada, whereby they may or may not be eligible to receive a work permit. And if they weren't eligible to receive a work permit, how would they be eligible, or what would they be able to do in order for the employer, in this case, to withhold and remit taxes? And what is the individual's responsibility? Would they be eligible to apply for a social insurance number in Canada, or what's referred to as the individual tax number, which is effectively a processing number for the CRA? It's a good question. I believe, and I've got Ernie beside me, so he'll hit me upside the head if I'm wrong, but my understanding is that the CRA, if you don't have a work permit, you cannot apply for social insurance number. So that's just the rule. So therefore, you're going to have to apply for an ITIN. So an ITN, individual tax number. It'll help process the return. You can still issue a T4 with an ITN. And the individual can still file an income tax return. Whether or not they should have received a work permit, that really falls on the immigration side and how that plays out. But from a tax perspective, you need to get it in, you need to get it filed. So an ITIN would be the option at this point.
From your experience, are digital nomads applying for work permits, or just visitor?
No. So the question is, do digital nomads need work permits, or do they have to apply for work permits? The answer is no. They would only come in as visitors. So if they're visa requiring, they would just need a temporary resident visa, visa exempt, and either an electronic travel authorization, or if they don't require anything, they just come in. But it would only be under visitor status.
I'll make a case. This is quite a common state. What's the like? Let's say I'm a famous DJ. I'm not.
There is a DJ set up here, so
You can practice.
I'm looking for a Canadian entertainment business. Am I coming in as a digital nomad, or I don't need a work permit, or do I have to be working for somebody outside the country while
Yeah. Thank you for the question. So the question was hypothetically, well, I think that's a very important part. The question was hypothetically, if you're coming in as a DJ working for a Canadian company, are you coming in working to work? Are you coming in as a digital nomad? Are you working for the Canadian company? So if you're coming in to work for the Canadian company, you would need the work permit, unless you qualify under some other work permit exemption. Sorry. You can only qualify as a digital nomad if you're coming in to work for your foreign employer who's outside of Canada, or you're working self-employed, but for providing services for people outside of Canada. It cannot be for someone in Canada. Does that answer your question?
Yeah.
Yep. Yeah, but that's the whole reason why you would need a work permit, and that's why the work permit category exists for employers who want to bring in employees or prospective employees.
If you're a US-based designer, let's say, and you've got clients in Canada, you couldn't come and work remotely in Canada without a work permit.
I'm sorry. So if you were a US-based
US-based independent contractor.
Okay.
But you have clients in Canada.
Mm-hmm.
You wouldn't be able to come to Canada as a digital nomad.
I would agree with that. Yeah. So the question is, if you're a US-based if you're a US-based graphic designer and you have clients that you do work for who are based in Canada, can you come to Canada as a digital nomad? I would tend to say no, just because you're providing services for people who are in Canada. So that could be considered work that requires a work permit in Canada. So I think in that case, you would need a work permit. If you were coming into Canada to just have, let's say, some meetings, you could qualify as a business visitor, but you cannot do any productive work that could be taking work away from Canadian citizens or permanent residents while you are in Canada.
Congratulations.
I think usually people can pass that if they just master the phrase, it depends.
So here's what we'll do say one more question, then Laura has tons of food and drinks for us that we all have to consume. So she'll bring that out, and then you guys can all mingle and ask each other questions. Any other questions?
Brittany, anything online?
I see some messages coming.
Oh, she just took the presentation off. That's why.
That's good.
Okay. So I think we are good. So thanks all for attending, and please stay as long as you like.
Oh, we have one question.
Oh, you do have a question.
Can you read that question, Brittany?
Yeah. So sorry, Tammy answered one, so we're good. But the other question is, if the digital nomad do not require work permits, there's a limit on the number of months and days that a visitor can stay in the country during one trip. Is that free movement allowed so frequently for digital nomads? Are there any tax implications because of my stay, or no, based on the number of days?
I think there's
so I think there's a whole bunch to unpack there, and I think we talked about a fair bit of it. I think we'll start with the immigration piece.
Sure. Yeah. So for when you come in, yes, there is a period of allowable stay. So it depends on what kind of document you have. If you get a visitor record and there's an expiry date, that's the date you're allowed to stay until. You can apply to extend it, but again, you can only work as a digital nomad up until that 6-month period. And then after that, you have to stop working as a digital nomad, but you can continue remaining as a visitor. If you don't have any documents which show what date that you have and that you can stay until, then it is a 6-month period.
Okay, so from that point, so if we're starting off with a 6-month limit, and we're talking digital nomad who we will consider to be either an employee of USCO or a digital nomad, so like a remote work arrangement, or the individuals in Canada as an independent contractor. I guess they can do that still as long as they're not working on Canadian product. There certainly is, if they're an employee and in Canada, there will be all the corporate tax requirements. I don't know necessarily that they'll become a tax resident of Canada. Again, more facts would be needed, but they certainly would be, the employer would be subject to all the payroll regulations in the absence of a tax waiver. be it at a corporate level, or the individual themselves can apply for an individual waiver. So generally speaking, they may not be subject to tax because they're working for again, a US co while in Canada for less than 180 days or no more than 180 days. And all their services are related to US co. So more likely than not, they would not be taxable, but US co would have the requirement to register for Canadian business number, payroll number, issuance of the T4, and the individual would have a requirement to file. Yeah.
Yes. So I think as you were kind of putting it, the whole issue around needs, because there can always be that impact on corporate. Again, whether that can be experienced from establishment.
Right.
So it's kind of critical.
Yeah. So just to add on, and I don't know whether anyone heard that, Brandon Vusen, who's one of our directors in our US corporate group, just added on the concept of permanent establishment and where that lands for the individual in their activities in Canada. So again, another piece that one has to consider. So everything really remains at the corporate level, and then more likely than not, the employee, if they're not a resident of Canada, at the end of the day, they may have a Canadian tax filing requirement, but they should not have to pay tax as an employee of a US company. Again, facts would be needed just to reconfirm, but again, that's typically where it should land. So if there's no other online questions, where is that one?
Nope. That's it.
That's it. All right. So,
well, thank you everyone for attending online.
Thank you. I'll play the music again so that you have some sound.
I think I said one point. You might tell me. No.